give it a second till. Just go ahead and start talking. Welcome, everybody. I'm Dale Sweet. I'm an attorney here in the state of Missouri, and I'm sitting here and coming at you from beautiful, fashionable St. Louis City. And as many of you may know, St. Louis City is an independent city. We are not in any particular county. However, tonight's presentation is going to be talking about buying property, losing property, having a lien on property in most Missouri counties. So where I'm sitting right now has absolutely nothing to do with what we're talking about tonight. So I'm coming at you live from the Sweet Law Office in beautiful, fashionable, and sunny South St. Louis. We're here to talk about tax sales in most Missouri counties tonight. And this is not legal advice. It's dissemination of public information. What I'm going to talk about here tonight does not necessarily fit your or anyone else's particular situation. Every property and every situation is always going to be unique. I suspect, but do not know, that my audience tonight is mostly hybrid investors. When I say hybrid investors, I mean people who have money, but who also have a truck and a caulking gun and a ladder and a crew and so on. I'm not your lawyer unless I am your lawyer, and the choice of a lawyer is an important decision that should not be based solely upon advertisements. Here tonight, we're on a live stream here on YouTube. I'm delighted to be with you. If you can submit questions in the chat down below, wherever that is, then I have people and dogs here who will interrupt me, and the dogs may interrupt me more than anyone else to let me know what is going on during the chat. The focus tonight is on St. Louis County. But most of the process that I'm going to talk about tonight applies to most Missouri counties. There's going to be a whole lot of words on the slides that you're about to see. And buying property for back taxes is difficult and complicated, but it is not as scary as you've heard. I hope tonight to dispel some myths and to provide some changes in the law that have occurred since the last time I did one of these videos last year in July. This is the state of Missouri. As you know, I'm talking to you now from St. Louis City. St. Louis City is not in St. Louis County. It's not in any other county. The rest of the state, including St. Louis County, uses a certain tax sale system that we're here to talk about tonight, but for Jackson County and the parts of Kansas City that lay outside of Jackson County. So if you've been to Kansas City before and you're driving around, you see entering Kansas City, leaving Kansas City, etc., etc. We're not talking about anything Kansas City tonight, but it's a lot like St. Louis City. And I do have a YouTube video for St. Louis City that you're welcome to watch at your convenience here on this same channel. Real estate taxes, that's what we're here to talk about. Real estate taxes do not bring personal liability. What does that mean? The government is unlikely to sue you or garnish your wages or otherwise try to recapture delinquent real estate taxes. Now that's completely different than personal property taxes, income taxes, small business taxes, earnings taxes, etc., etc. We're talking only about real estate taxes. Here in the state of Missouri, those are due annually on December 31st. And what do they pay for and what happens if they're unpaid? That's what we're here to talk about tonight. Your real estate taxes pay for museums, so that's the St. Louis Art Museum and a statue out front called the Apotheosis of St. Louis. Here's the St. Louis Zoo. The St. Louis Zoo and the St. Louis Art Museum that we've just seen are both in St. Louis City, where I am, but they are also paid for by county property taxes. Schools, so here I think we have a member of the Parkway Central football team, Go Colts. Now, I'm really close to Roosevelt, so I would say go Rough Riders, but whatever. And if I got Parkway Central wrong there based on the uniform, somebody will crucify me in the comments, but you know what I mean. This also pays for the St. Louis County Public Library. This is the brand new library across from Grant's Farm on Gravois. Back taxes. What are we talking about here? So, selling the government auction to sell real estate because somebody didn't pay his or her taxes is an age-old method that comes from us from farming England. The idea, of course, was that the earth paid the taxes by means of crops, chickens, turkeys, tomatoes, etc., etc. You're going to hear me talk about tomatoes again in this presentation. And that's a legal fiction. Everybody knows that the earth doesn't write a check. And today, it's more often a taxpayer, a human, a corporation, a company, or a mortgage company or a mortgage servicer paying the taxes. There's an Alabama song that includes the lyric, "The county got the farm and we moved to town." Well, how did the county get the farm? It got the farm because we didn't pay the taxes. County taxes are a high priority lien, which means that when that lien is foreclosed by the process that we're about to talk about tonight, everything else down the stream is wiped out, but for certain things. If I could tell you but for the certain things in just 2-3 minutes, well, I would, and I'd be home right now. But it's a little bit more complicated than that. Whenever we're talking about the government selling our property for back taxes, we are talking about the 5th and 14th Amendments to the United States Constitution. That's double jeopardy. You can't be tried twice for the same crime. That's pleading the fifth, or being compelled to testify against oneself in a criminal proceeding. It's eminent domain. Can the government take away our property and sell it to somebody else without just compensation? No. But what we're talking about here is a deprivation of property, specifically the deprivation of real estate, without due process of law. And due process of law in the context of a tax sale means that the government, or we will see soon, the tax sale certificate purchaser is required to provide notice and a chance to redeem. Buying real estate for taxes, as I said, is technical and specialized. It's not as risky as you might hear, but it's not without risk. And why? Well, a tax sale represents a break in the chain of title. In my example here from South Park, Eric Cartman sells to Kyle. Kyle sells to Kenny. And then out of the blue, out of the sky, the collector of revenue sells the property to you. Well, Kenny never signed anything. Kenny might have money problems. He might be a deceased, disabled minor child who's incapacitated, incarcerated, and a deployed service member who has a common name such as Kenny or Ron Jackson or Sally Smith or Bill Thompson, and may not even exist, and may have owned a property with unpaid sewer bills, oh my gosh, and may share a name with somebody who did not pay federal taxes or has a federal judgment against them. We're going to navigate through all of this in the next hour or so, folks, and I hope to keep it quick. We might go a little over an hour. Submit your questions in the chat if you like, and we'll just keep on plowing forward. When do these tax sales occur? In St. Louis County and other Missouri counties, except for Jackson County, that sale will occur on the 4th Monday in August, or roundabouts. We'll get to that in a minute. In Jackson County, which we're not talking about here, those sales begin August 15th in Independence and August 22nd in Kansas City. In the city of St. Louis, which is not in a county and which is not what we're talking about tonight, we will have one more sale this year beginning Tuesday, August 23rd, and that's it for this year. Redemption is a word that I used a moment ago. Due process means notice and a chance to redeem. What does redeem mean? Well, as a religious person, people know that redemption means to cleanse oneself of sin. In the tax sale context, it means to pay some amount to keep the property interest and avoid the sale, or a collector's deed, we'll get to that, going to a tax sale purchaser. Basically, what do I need to do to clean my property up by paying whatever amount toward those schools, the Parkway Central Colts, the library, the art museum, and so on, in order to keep my property? If you know someone whose property is on one of my lists, on a government website, and it's about to be sold, that person should contact the collector of revenue in their county right away. But also remember that what we're about to talk about is that there's usually a right to redeem or pay the taxes and keep the property that exists after the auction. Now that's different than a government sale in St. Louis City or in Jackson County. So let's talk about the differences here. In the left-hand column, I have the city of St. Louis and Jackson County, in which case the government does a lot of our work for us, and there is no right to redeem a property after an auction unless there is a defect, a technical defect in the sale. In most counties, such as St. Louis County, Taney County, Callaway County, Crawford County, Boone County, Hickory County, Stone County, etc., the buyer is on her own. It's an administrative system rather than anything overseen by a judge. Instead of getting a sheriff's deed or a deed from a court administrator, the buyer eventually, if they're lucky, ends up getting a deed from the collector. There's only one sale per year. We're doing this in July because there's a sale in August, and that's all there is. We're operating under the Jones-Munger Act, which is contained in Chapter 140 of the Revised Statutes of the State of Missouri. And under the Jones-Munger Act, the legislature back in the 1930s has delegated due process required by the 5th and 14th Amendments to that tax sale bidder. And so when someone shows up at that auction and bids, she will now step into the shoes of the government and be required to send certain notices, take additional reasonable steps in order to make sure that Kenny, well, never mind about him, has the opportunity to redeem his property that was sold to that bidder at the auction. Usually we do not need an appraisal. In fact, we never do. There's usually a right to redeem. The buyer will get her deed from a clerk, her certificate, we'll talk about that in a minute, from a clerk in the government building, but not from a judge. So this is not overseen by a judge, and that's important because if anybody who's ever been through a probate estate or a divorce knows that a judge in the state of Missouri can absolutely affect, change, clarify the title, who owns real estate in the state of Missouri. Therefore, because this is an administrative system not overseen by a judge, the tax sale purchaser will usually need to file a separate quiet title lawsuit, we'll get to that, or perform other remedial efforts in order to shore up or clarify her collector's deed. Under this system, we also have things that happen after the first, second, or third sales. We're going to talk a whole lot more about those in the next hour, but those include post-third lists, the trustee list, or transfers to municipalities located within the county. What kinds of properties are we talking about? Well, tonight we're going to talk about a lot of different things, and I'm going to have a couple of examples. The examples happen to be both residential, but the collector of revenue is selling all kinds of properties. And some of those are vacant lots, some of those are vacant buildings, some of those are occupied buildings, they're residential, commercial, they're trustees' land or common ground in subdivisions. They're irregular and odd lots. In most counties, and especially in St. Louis County, you should watch for the letters A, R, and H showing up in the posted street description of a property. Why? Because those properties are usually not what you think they are. It's always important to check the legal description. This is absolutely a buyer beware situation. And under the Jones-Munger Act contained in Chapter 140, a tax sale in most Missouri counties does not extinguish an easement, such as a neighbor's driveway, utilities, etc., etc. How are these properties advertised? Well, they're advertised in a newspaper. In St. Louis County, that happens to be the Legal Ledger. This is the Legal Ledger from Tuesday, and it has a long list of properties that are to be sold. In every other Missouri county, there will be some sort of published notice of a tax sale. And if you want to know in what newspaper that appears, you'll want to contact the county collector of revenue in the relevant county. They often, but not always, post the things on their websites also. So for St. Louis County, for instance, the list that we're talking about here tonight is on St. Louis County's website, but it isn't always. Now, I have a free email list. I'm not your attorney unless you hire me. This is not legal advice, and you are absolutely welcome to sign up for my email list. My email address is Dale@MissouriTaxSales, plural, Dale@MissouriTaxSales with an S at the end of it.com, and I will share that again at the end of the presentation. And I send out emails these days mostly for St. Louis County and St. Louis City. You should always be careful with the street address of the property that you're looking to buy, because frequently the street address is going to be or is absolutely misleading. This is an example of the kind of map that I send out to persons who choose to join my free email list. This happens to be the list geocoded to a map for St. Louis County's tax sale that begins around this time next month. And you can see there by the little pies what properties are to be sold in St. Louis County, which stretches all the way from Spanish Lake to Valley Park and so on. And you can also see where the highest concentrations, based on the big fat donuts, of properties that are tax delinquent for 3 or more years are located. How do you investigate these properties if you're interested in them? Well, most people these days start with Google Street View, but you cannot believe the image that you see on your screen. The Google van goes down the block from time to time, maybe recently, maybe not recently. I've had clients buy properties at government auctions and just based on looking at Google Street View. And then they say, well, the property is torn down. All that's left is some trash bags and a few discarded tires. That's your bad. So you always need to go there. There is no right to inspect properties, to bring over an inspector, to test the ground fault outlets, to check out the roof and so on. You should always, or should always consider talking to people on the block, talking to the owner, talking to the occupant. You might consider a drone. It's probably illegal. You can look through county websites and geographical information software. We'll get to a couple examples on that later. But you should always check the legal description carefully, the land records. Check to see if the property has been redeemed before the auction, meaning enough taxes have been paid to keep the property out of the auction. Should you get a title report beforehand? We're going to get into that in much greater detail in a minute. Here I have a couple of random examples from the recent St. Louis County mailing list, or tax sale list. They both happen to be residential, I believe. I chose them at random by poking my thumb down in the Legal Ledger newspaper. These are not addresses that anybody has asked me about. These are simply things that may, by what we're about to do here, prove illuminating. I have other random examples in my video that I did for St. Louis County's post-third list. So if you're interested in these kinds of examples and how to do this kind of investigation on your own, you should absolutely look at the St. Louis County post-third list video, which is also on YouTube. So I'm going to navigate over here to Firefox, and I'm going to bring up a new tab. And in this new tab, because I'm talking about St. Louis County mostly tonight, I'm going to put in St. Louis County Real Estate Lookup. Going right here. Picked one of the first couple of things that popped up, and I'm going to click right on here. And I am going to click over here to the slide for a minute. It's 6305 Southwood. 6305 6305 Southwood. When this comes up, I also know from my example and where I put my finger down on that legal newspaper that it's Unit 3W. Based on what I see on this screen, I suspect but do not know that this is a condominium unit. We're going to find out here in a minute. I'm going to click on that address. Remember here I'm on St. Louis County's website. Scrolling down here, I see that our delinquent taxpayer is named William D. Aldrich. I see that the taxing address is at that particular Clayton condominium unit. The mailing address for that condo, or where the tax bills go, where the owner is probably the same as the taxing address. I see that the city name is Clayton. We already knew that this was in Clayton, Missouri, and I see that this is a condominium unit in Southwood Condominiums. I see that it's Unit 6305 3 West. It also includes a legal interest in the common elements of the condo, such as the common stairwell and so on. Up above here, if I click on tax history, this comes up to show that the 2019, 2020, and 2021 taxes are unpaid. We're going to see here in a minute through some other examples that means that the collector of revenue in St. Louis County will be attempting to sell that property for the first time this year. And what will be the opening bid amount? We'll get to that in a minute. Let's go to tax info and receipt. We scroll down here and we see that the amount is $18,006.27, $18,000 and change. It also says here that this property will be offered for sale in the August tax sale for the first time. What did I tell you, folks? Contact our back tax section for more information. Well, good luck. Anyway, so $18,000, $18,006.27 is our sticker price on this particular property. We believe it's a condominium unit. We should absolutely go out there and look around. Now, if I put in the same address, 6305 Southwood, and then I clicked over here on the map icon, what will happen is that I'm looking at an overview from the county's website using geospatial information systems of where we're particularly talking about. And if I move over here, I see that this is Skinker, this is Forest Park, this is still the city of St. Louis for a short number of addresses. And when I move over here, we are now in the county. And our condo unit is located here somewhere in what appear to be 3 buildings in what I would assume to be the Southwood condominium complex. Moving now to our second example, it's 8013 Schoolway in Kinloch. So here I'm going to put in, and by the way, I know that we've had a couple of questions come in. The land use code is something beyond the scope of what I'm doing here, but that would be a question for the county zoning office. And how much time do we get to redeem? We are absolutely going to get to that. So going back to our next example, we're at 8013 Schoolway. And by the way, folks, I did not look up these addresses earlier. We're doing this on the fly. So I'm here on the county's website again. I see 8013 Schoolway. I pull this up. I see that the property owner's name is Keener or Kenna Buford with a taxing address and a mailing address that are the same. I see this is located in the municipality of Kinloch rather than Clayton. I move down here. I can see the lot dimensions because now we're not talking about a condominium, which is a box of air in the sky. Rather, we're talking about physical real estate. And specifically, this lot appears, no guarantee, certainly not from me, on the county website to be 50 feet of street frontage by a depth of 109. And if we go up here and click on tax info and receipt, we will see that the sticker price or the opening bid amount is going to be something more like $6,100, unlike our Clayton condominium. This property will also be offered for sale in the August tax sale for the first time, and you can contact the Collector of Revenue for more information. Now, moving back to our first screen here, I'm going to click on that map icon. I'm going to move this little thing over here so we can all look at it together. And I see that we're looking at a property that is located roundabouts the intersection of Schoolway and Thurston in the city of Kinloch. It's probably this one here. It might be this one. It was 13. So we're talking about this property right here, 8013 Schoolway Avenue. So that is an overview of the property. At the time that this satellite took this picture, there was a building there. There is no guarantee that there is a building there now. There's no guarantee that somebody does or doesn't live in that building. There's no guarantee that that isn't a toxic waste dump or a meth lab, or that the Clayton condominium isn't either, by the way. And there's no guarantee that there aren't alligators in that swimming pool. However, we can also, to clarify our position, just go over here to regular old Google. 8013 Schoolway, St. Louis, specifically Kinloch, 63140. Now, I haven't done this before. I think it'll come up. Yep, there we go. We're here at Schoolway and Thurston in Kinloch, right down from Airport Road. And when I click on this picture, I see what appears to be an absolutely beautiful house. Probably owner-occupied based on the taxing and mailing address being the same, but zero guarantee. The collector is selling to you whatever the collector is selling. If you know the people who live at 8013 Schoolway, they should contact the county collector and try to arrange for redemption of that property at their earliest possible convenience. So I'm back to my random examples, and we're done with that. We're talking tonight about most Missouri counties and about the Jones-Munger Act, which is the way we do tax sales in an antiquated 1930s system with messy updates to the law over time. Under this system, you are usually buying a lien. Now, if you watch these videos on YouTube and so on, you will frequently see the question, oh, is Missouri a lien state or a deed state? Is Colorado a lien state or a deed state? How about Atlanta, Georgia? How about Texas? The answer to your question in terms of Missouri is yes, both. Under the situation that we're talking about tonight, we are mostly buying a lien that can blossom or turn into the fruit of a deed, depending on whether certain things happen in the meantime. Unless it's a post-third sale, and I have a separate video on that, so go watch that if you're interested in the post-third list. What happens is the taxes go unpaid. The taxes only have to be unpaid and delinquent for a few days for the Collector of Revenue to start this process. So if the taxes are due on New Year's Eve, 2021, on January 2nd, 2022, the Collector of Revenue may start this process, but usually does not. It varies by county. St. Louis County usually waits 3 years of back taxes before they begin the process. Then the collector offers the property, and when they say the property, they really mean a lien on the property. It's legal fiction, folks, and there's one sale a year under this system in most Missouri counties, and it's always going to happen around the fourth Monday in August. If somebody wants to keep her property out of the tax sale, such as that one on Schoolway in Kinloch, some taxes need to get paid before the morning of the sale. How much depends on the county, because collectors of revenue in Missouri counties have a great deal of discretion. Always remember, folks, this is a tax collection strategy. It is not a real estate marketing strategy. So if you're watching this video because you're tired of probate, you're tired of the MLS, the prices have gone so high, you send out postcards and so on, we're talking about a completely different animal here. What if you decide to bid? What should you do? Well, it depends on the county because those collectors have a lot of discretion. St. Louis County is unfortunately using sealed bids against this year. It will not be a public auction where people are raising their hands. And the reason that they're using for that this year is that the county council chambers, which is the usual auction venue, are being renovated to comply with the Americans with Disabilities Act. If you are choosing to bid in St. Louis County, you are going to want to look at the information and the forms on their website. If you choose to subscribe to my email list, I will email you a link to the website, but it is just as easy as typing it in. Let's just go ahead and do it right now. Back here to Google and my picture of the house in Kinloch, St. Louis County tax sale 2022. Real property tax sale. Here are the rules. New bidder registration form, first and second sale listings that we're talking about, third sale listings, and appointment of an agent for a non-resident, in addition to other earlier years' auction books. So the county has your back. All the information is there. They're a little picky when it comes to some things. For instance, they want you to fill out the form using a PDF rather than writing on it and so on. But the collector has a lot of discretion and they can say that. You will also have to fill out an affidavit, as you saw on that last screen, that says that you don't owe any taxes to the county. Can you owe taxes to the state of Missouri or the IRS or some other entity, maybe, not beyond the scope of what we're doing tonight? But you have to be a Missouri person or a Missouri corporation or company. What does that mean? Can I get off a plane from Florida or Alaska and bid in Clayton or Steelville or Potosi at a government auction? No. I will have to appoint a Missouri person who can be served with papers in the state of Missouri in order to represent me when I bid. And that person probably needs to bid also, but it's up to the collector. So someone from out of town who is interested in bidding on a property located in the state of Missouri at a government auction is probably going to want to form a limited liability company or other entity in Missouri and appoint a registered agent here. If you bid on a property and you win, you will need to pay the successful bid amount and the cost of recording the certificate of purchase. What's a certificate of purchase? That's your lien. That's your lien that shows up in the land records to indicate that you, the bidder, have got some sort of financial or budding, but not whole, ownership interest in the property as of the time of that auction. Speaking just a little bit more about St. Louis County's sealed bid process, it has gone all right the last 2 years. They started doing it this way due to COVID, to not have so many people in a small room. Most of your county collectors across Missouri are going to have these auctions on the courthouse steps, in a public lawn, at the courthouse square, at a government building, or otherwise, and most of them are going to be outside, outdoors. Not all of them. So St. Louis County's auction used to be in the county council chambers at the government building in Clayton. However, that room was not available for the last 2 years due to pandemic. It is not available this year due to renovations. Therefore, the county, St. Louis County, is going to handle the auction by sealed bids again. The dates, the times, all the instructions are on their website. I showed that to you just a minute ago. The general timeline you've already figured out from what I've been saying, but that is in St. Louis County, usually 3 years of taxes go unpaid. Now, they could start with only 1 year, 2 years, but they wait for 3. And so on the third year tax delinquency, the government has to start its process by putting ads in a legal newspaper, by sending out notices by mail, and so on. And they do that during the first 8 months of the year. leading up to the first sale in August 2021. What does a first sale mean? That means it's the first time that the government has offered the property for sale at a public auction on this particular stretch of tax delinquency. And so if somebody bids on it at the first sale, there will be no second or third sale. There will only be a first. If, however, nobody bids on that property at the August 2021 first sale under this example, why then the status quo will remain for another year, during which time the taxpayer may absolutely pay her or its or his taxes and prevent the property from being sold to a bidder at an auction. However, if those taxes do not get caught up, now, if you follow me, we're at 4 years of back taxes because the 2021 taxes didn't get paid either. So in August 2022, that's going to be what we call a second sale. Again, if the second sale does not actually occur, nobody bids on the property at the second sale, then the status quo is going to remain for yet another year until we come up to August of 2023, at which time we will have a third sale. At that time, we now have 5 years of delinquent taxes, so there will be a shorter right to redeem. We have a question in the chat about the time that they have to redeem, and I'm going to get to that here in just a minute. Know, however, that it's shorter on the third sale. If something doesn't sell 1, 2, and 3 years in a row, why then it's going to go on the post-third list, and that's covered in a completely separate video that's available for you to review at your leisure. Pop some popcorn, folks. St. Louis County waits 3 years, but other counties do not. St. Charles County, for instance, waits 2 years. So you can shorten the timeline and reduce the opening bid amount by 1 year based on this example. Crawford County, the county seat is Steelville, only waits 1 year. So an example here for Crawford County is that the 2020 taxes go unpaid. Therefore, in August of 2021, you're going to have your first sale. August of 2022, you're going to have your second sale if nobody bought it the year before. In August of 2023, you'll have the third sale, and so on. In most Missouri counties, a right to redeem usually exists, but you need to always be aware that the rights to redeem can be extended, and there may be problems with a sale based on disability or incapacity, as those things are defined in Missouri law, and specifically in Chapter 140, and maybe in United States Bankruptcy Code. The buyer, as I mentioned before, will always handle the due process. What does that mean? You're going to order a title report. You're going to send out notices by regular and certified mail. Now, I do that for my clients who want to pay me to do that, but it's also something that you can do yourself if you care to. You'll have to monitor the returned mail, and if certain combinations of returned mail come back with yellow stickers and so on, you may have to perform additional reasonable steps to attempt to provide notice of the tax sale and the right to redeem to the taxpayer, to the taxpayer's heirs, the taxpayer's lien holders and creditors, etc. Because the tax sale occurs in August, you will have to pay an additional year's taxes in December of the tax sale year in order to obtain a collector's deed the following year, maybe. You can also pay those taxes later, but you'll be paying penalties and interest. We'll get to that. Under the system that we use in Chapter 140, the buyer will get a collector's deed. A collector's deed does not provide good and marketable title, and therefore a quiet title suit is almost necessary in order to shore up the kind of quality of title that a bidder gets when she obtains her collector's deed. There are never any guarantees. We have a good question right now on St. Louis County's process, and specifically the question is, how does this sealed bid business work? Well, the sealed bid business works the way it says on the website. You fill out the forms, you send the stuff in, You drop the stuff off, etc., etc. You fill out a form that says, I will bid $10,000 for the property on School Way in Kinloch, and you include a $10,000 check for your bid amount and an additional $30 check to record your certificate of purchase. So you're going to have 2 checks in there along with your completed bidder form. If you choose to bid on multiple properties, then you have to have enough resources, which means money in the bank, in order to cover all of those checks. If you don't, something's going to bounce, or something will likely bounce. So if you submit that $10,000 check and somebody else, such as me or somebody else, the neighbor, et cetera, chooses to send in a $12,000 check or a $12 million check for the house in Kinloch, then you will get your check back. But you do need to have enough money to cover the checks that you use to submit in the sealed bid. And this is a problem with a sealed bid auction, folks. The reality is that if you went to a car auction and you lost your bid on the Buick, you got your bid on the Corvette, then you would only have to pay for the Corvette, right? And if you had $5,000 and the Corvette went for $4,000, you wouldn't also have to write a check to pay for the Buick. But that's not what we're dealing with in a sealed bid system. In a sealed bid system, you have to have all these checks included, and they need to all clear. Moving on along from that question, now we're going to get to the various timelines to redeem. We have a first and second offering sale. Those are functionally the same under the law, but obviously the price is different, because if you bought it at the first sale last year where no one bought it, and it is a lien, if you bought it on the second offering, then the taxes have gone up by an additional year. There is at least a 12-month or 1-year right to redeem on a first or second offering sale. The tax sale purchaser or circumstances can stretch that 12-month right to redeem into 18 months if you choose to. On a third sale, there is at least a 90-day right to redeem. So remember, folks, by the time we get to the third sale, the taxes are super delinquent. Therefore, the right to redeem has shortened to 90 days from at least a year. And the reality is that it's 90 to 135 days because you have to do something within 45 days, and we're going to get to that. Then there's the post-third list, trustee sales, and so on, which are covered in a separate video that I already have up on YouTube. On a first and second offering, as I said, you're buying a tax lien. You're a hybrid investor, so maybe you'll get the real estate later. The certificate of purchase is the recorded lien. During the redemption period of 12 to 18 months, the bidder is a trespasser, probably, and is probably not responsible for mowing, liability, building code violations, etc., until that bidder eventually gets a collector's deed because they want it and because redemption didn't occur. But University City will still tear your house down, and Jennings will still bill you $250 a week to cut your grass. That 1-year right to redeem can stretch to 18 months. If you bid at one of these auctions, you are the successful bidder, you get a certificate of purchase, and you do nothing more forever, then your lien will wither and die. I have an example on that in a minute. You will need to pay the additional year's taxes as they become due or shortly thereafter. Why should you do that? The law requires you to do it, and it raises the bar for redemption to occur. That is, how much needs to be paid in order for a taxpayer or a lien holder to retain their property rights that are being deprived of them under the 5th and 14th Amendments. Therefore, this auction occurs in August. Most people, but not everybody, there's a strategic way to do this, wait until at least March 1, April 1, May 1 to get started. Sometimes in the meantime they get a check, The property is redeemed, they are cut off, they are gone. Sometimes the bidder will order her title work and send out these redemption notices March 1, April 1, May 1, June 1, and the property will be redeemed then. That's fine. If 90 days pass or 1 year, whichever is longer, from the time period when the redemption notices were dispatched, then presumably the tax sale purchaser or bidder will be eligible for a collector's deed. Now, if redemption happened to occur, then the lien holder or the taxpayer or the granddaughter or the nephew would need to pay everything that was paid by the tax sale purchaser, plus 10% interest on the opening bid, 8% on the additional taxes, and 0% on the overbid or surplus. So, for an example here, and I probably should have a slide for this, if the opening bid amount was $1,000, the additional year's taxes were $100, the tax sale purchaser pays $1 million to the collector for the tax lien. Why then, if redemption occurred, the taxpayer or the lender or the granddaughter would need to pay $1,000 plus 10% interest because that was the opening bid amount, $1,000 because that was the additional year's taxes paid by the bidder plus 8%, but the tax sale purchaser or bidder would get back the rest of the $1 million with no interest. The collector calculates all of this for us, and redemption happens through the collector. What does that mean? You don't go around and knock on doors and tell people you have a lien on their property, unless you strategically decide you want to do that. If somebody wants to pay off the lien, redeem the property, they actually go to the county collector in Potosi or wherever. They do not go to the tax sale purchaser. You totally don't have to talk to the taxpayer as an investor bidding at one of these auctions, but you may. As I mentioned earlier, and I know I did it kind of fast, the buyer will not be eligible for a collector's deed until these notices have gone out, certain additional reasonable steps have occurred under certain situations, at least 90 days have passed from the date that the redemption notices went out, or at least a year has passed, and at least a year has passed since the first or second offering tax sale. Right here, folks, first or second offering. When you are a successful bidder at a first or second offering and you do everything on the previous slide correctly, you will be eligible for a deed. You will have to fill out an affidavit to the collector. Your attorney can help you with this. It will outline the constitutional due process efforts of the buyer and specifically the buyer or bidder or purchaser or lien holder's efforts under Section 14405 of Missouri state law. Missouri state law requires you to send out notices by regular mail and certified mail. But if certain combinations of the mail come back undeliverable, you probably need to do something else also. Maybe you need to, even if certain combinations of the mail come back. And so the affidavit presented to the collector will be the trigger. That is the demand. That is the reason why the collector would give you a collector's deed. Nothing happens after that auction automatically. Remember, folks, this is a tax collection strategy. It is not a real estate marketing strategy. When you demand your collector's deed by providing an affidavit to the collector, you will have to pay the previous year or year's taxes if you haven't done so yet, and the collector is going to want an additional 30, 40, 50, whatever dollars in order to pay the recording fee for the collector's deed. At that point, you will soon, or do, depending on the county, have a collector's deed. That means you own the property. but that's never enough for insurable title. So if you want to borrow against the property or sell it to someone who wants a title company closing and needs a loan to pay your purchase price, you will need to do something more. Now, that something more is probably going to look like suing, hiring an attorney to file a lawsuit to quiet title. We'll get to that. Or to collect deeds and releases from creditors, lien holders, and taxpayers in the particular situation. Moving on now to third offering sales. Remember, folks, on a first or second, there's a 1 year to 18-month right to redeem. But on a third offering sale, the collector has offered the property for sale 2 prior Augustes, but nobody bought it. Therefore, if you are the successful bidder at a third offering sale, you will be required to stick to a stricter timeline. Because based on the tax delinquency, there is a shortened right to redeem. During the next 45 days after that auction, regardless of when you hear that you have won, ding, 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 St. Louis County sealed bid process, you must order a title report and send out your redemption notices within 45 days of that auction, or you lose. Your redemption notices will indicate a 90-day right to redeem from the notice date. What does that mean? The right to redeem is 90 to 135 days, because 90 plus 45 is 135. You will mail out these redemption notices and then post the property or engage in whatever additional reasonable steps are required under the Constitution and Section 144.05. If redemption does occur, why, you get your money back based on that same little description here that we were talking about. 10% on the opening bid, 8% on the additional taxes you paid on New Year's Eve, etc., etc. And then you will need to sue to quiet title, or get deeds or releases at the point that you have received a collector's deed to the property. I usually at this point have a question about possession or eviction or who's allowed to be there, but we'll get to that if we have that question or when we get to it. How do you get your collector's deed? You do everything just right. You follow the timeline, you follow the rules. You do not need to be an attorney to do those things. You simply follow the law. However, it is complicated, and my staff, and people like me are for hire to do those things. Pay attention to state law, pay attention to the case law, pay attention to the changes over time. When you present your affidavit, the collector will have discretion. That means the collector can decide that what you did wasn't good enough and you need to do it over. On a first or second offering tax sale, it is therefore incumbent upon that purchaser to do the things prior to the expiration of the 12-month right to redeem. Because if she does not, and the collector chooses to reject her affidavit, why then she needs to have more time, such as that 6 months between the 12 and 18 months, in order to perfect her notice efforts to the collector's satisfaction. When you present your affidavit, as I mentioned earlier, you have to pay any additional year's taxes, 1 or 2 years that may have accrued, pay a recording fee, and then what happens? You get a collector's deed. Good for you. You really own the property at this point, but you have a title problem. You also have possession of the property, but for other people being in possession of the property. The collector's deed does not give you a right to order someone off of a sofa, for instance. What do you do then? Generally speaking, once you have a collector's deed, your attorney will advise that you sue to quiet title. A quiet title is a lawsuit that has one person with an interest in the property on one side and everybody else with an interest in property on the other side. This person sues these people, and we let a judge sort out who has the best title to the property. When we do a quiet title, we can also, if necessary, and only if necessary, include a separate section of that lawsuit asking for ejectment or eviction of occupants if they are stubborn, no lease can be arranged, etc., etc. A sewer bill will survive a tax sale in the state of Missouri and always have, based on a particular statute that's been clarified in a court case that came out last September. We'll get to that in greater detail in a minute. There are also problems with municipalities, HOAs, and condos asserting that their liens survive the tax sale. Maybe they do, maybe they don't. Maybe they timely presented them to the collector, et cetera, et cetera. Maybe they got sued in the quiet title. This is just part of the difficulty or gray area in which we're talking. Every single situation is unique. On a post-third, that means the property didn't sell 3 Augustuses in a row. And that means if you've been playing along under St. Louis County's policy, 3 years of taxes would have been unpaid prior to the first auction, then the second, then the third. So we're going to have at least 5 or 6 years of back taxes by the time we get to a post-third. I am not talking about post-third sales tonight. Post-third sales are the first time in Missouri where the price can go down and become what I call an offer instead of a bid. A bid I'm using here as a term at an auction where the price goes up because people are bidding against one another. I cover all of this in a completely separate video, and I'm not going to do this here tonight. In your quiet title lawsuit, who will the defendants be? Well, we'll get title work when we do the redemption notices because the law requires it. And then we may update that title work at the time that the collector's deed has flown or been given to the tax sale purchaser. We usually try very hard to find specific people and place papers in their hands. So we have now moved from phase 1, which is a notice and a chance to redeem, to collector's deed has been issued and there probably is no longer a right to redeem. At this point, your attorney is going to engage in some skip tracing, look up people, try to figure out how to put papers in their hands, understanding, of course, that many times taxpayers who lose their property at a government auction are deceased, are incarcerated, are in the service. Go back to my South Park example, right? We also have a lot of lenders that used to exist but don't anymore since the 2008 crash. When the time comes, your attorney can advise you about the concept of personal service and service by publication. Title company underwriters in general are dreadful and do not like tax sale property. It is frequently difficult to borrow against or sell property that you have purchased for back taxes, no matter what you have done, no matter how good your attorney is, since that auction, through the issuance of the collector's deed, and through the completion of the subsequent quiet title. I'll get to that more in a minute. The Jones-Munger Act, for instance, is not super helpful. It doesn't spell out exactly what's gone and what's not. The case law is all over the place, and then we already talked about eviction. The Eclipse decision is a case that went to the Missouri Court of Appeals out of Jefferson County on a tax sale, and it did not involve the Metropolitan St. Louis Sewer District, and an opinion was released from the Court of Appeals. It is binding on Missouri courts in the Eastern District of the state, and it says that sewer bills survive a tax sale and always have. It is not a new law. It does not matter when you bought it, before eclipse, after eclipse, etc., etc. MSD is not part of that case, but it is alert and reacting. And MSD is no longer writing off sewer liens, transcript judgments, etc., etc., based on the presentation of a sheriff's deed in the city or a collector's deed in St. Louis County. This was affirmed by the Court of Appeals in September 2021, and for now is good law in the state of Missouri. The other thing to really worry about beyond the sewer lien is federal liens. And what do I mean by that? I mean income taxes. And you might say, well, Dale, you said income taxes don't matter. We're talking about real estate taxes. We're talking about the Parkway Central Colts. We're talking about the library. We're talking about the zoo. Yes, yes, yes. But if I do not pay my federal income tax, the IRS will record a notice of federal tax lien in my jurisdiction. If I own real property or real estate in my jurisdiction, then my real property now has a lien against it to pay my federal income tax, which means I can't sell my property with a warranty deed and a title company closing without satisfying the federal income tax lien. Other examples of federal tax liens include the Department of Justice for criminal restitution or otherwise, the Department of Housing and Urban Development, or HUD, and so on. There is a case that is currently up on appeal that says, in federal court, that says that that federal tax liens survive the administrative sale of the Jones-Munger Act. So if there's an IRS lien, Department of Justice, HUD-backed mortgage, et cetera, it may survive the tax sale. Just one of the many pitfalls, folks. And now I have a video on pitfalls. What do we have to worry about when we're doing this? Well, everything but nothing. Tax sales are risky, but not as risky as you've heard. We have to worry about tricky municipalities who record their nuisance and grass mowing charges late, HOAs and condos that don't get it, superhuman huge sewer bills, federal tax liens, just talked about them, bad legal descriptions, inconsistent judges, a person who is a taxpayer alleging that she was disabled or incapacitated and therefore has more time to pay, bankruptcy filing, the problem that the property could be a casualty during the redemption period, during which time an insurance company may be unwilling to insure the property. Another pitfall is just simply bidding on the wrong property, bidding on some little triangle, watch my post-third video, that you didn't really want, an odd lot, a half lot, the A, R, and H designations that I mentioned in a street address from St. Louis County earlier. We may have to worry about those occupants. Many times I've had clients who have bought property for back taxes, and the occupant or tenant is an absolutely wonderful person. Sometimes a former owner-occupant who now becomes a tenant, sometimes the best tenant in the world who rented from a landlord who had a gambling addiction. There is no reason to wholesale kick people out of property. However, one of the pitfalls here is that you have to deal with occupant relations if there is an occupant. Your attorney can instruct you on that. You also inherit code problems in demolitions. If University City, those horrible people that they are, choose to tear down your lien holder interest during the redemption period, they can also stick on as a special tax bill the cost of the demolition. It's unbelievable. And I talked earlier about easements. The trouble with easements, of course, is that under most circumstances they survive a Jones-Munger Act or most Missouri counties tax sale. What kind of title issues does a bidder have when she emerges from this process? Well, your attorney can get you good title in most cases with a quiet title lawsuit or other curative measures. However, your buyer will be likely to choose the title company, or her lender will be likely to choose the title company, or your lender, if you choose to borrow against your property, will be likely to choose the title company. And many times your buyer's title company or your title company's underwriter will want to see much more process than is due. That is, they will want to see superhuman efforts that are greater than the law requires. Why? Title companies are risk averse. Title insurance, unlike car insurance, health insurance, and so on, is a one-time premium paid at closing. They don't ever expect a claim. And so they want everything fixed before they issue the policy. They don't expect any sickness or car crashes or whatever we have with other kinds of insurance. And so therefore, they will want seasoning, such as 1 year or 10 years or some crazy number after the issuance of a quiet title judgment. They think they can write their own laws. And frankly, folks, the effect that these underwriting standards have on our underserved communities amounts to systemic racism. These companies do not necessarily intend to be racist. However, their actions and their underwriting standards create a disproportionate effect that hurts Wellston, Pagedale, Pine Lawn, Kinloch, other underserved and underinvested municipalities and areas in St. Louis County, Castle Point, Glasgow Village, and so on. These people are not necessarily bad people. Their actions have a terrible, terrible, terrible effect. They need to be held to account for it. I have a couple of examples that I can just sort of talk about extemporaneously. I had somebody in St. Louis County one time who bought a toxic waste dump. And by toxic waste dump, I mean, that's a joke. I should put quotes around it. But really, they bought a property that had some environmental waste on it that was part of a greater collection of parcels that once had an oil refinery and so on. And once they realized at a first or second or third offering tax sale, whatever it was, that they had bought the wrong thing and they didn't really want it, but they had money invested in it, they said, hey, what should we do? And the answer to that question was, send your redemption notices early and often. Send them immediately. Offer a taxi cab to take somebody. Research the board of directors. Call people, Facebook people, show up at people's houses. Do everything you possibly can in order to make redemption occur so that your overbid or surplus money comes back, your sticker price comes back plus 10%, and any additional year's taxes come back plus 8%. In that particular toxic waste dump, redemption did not occur. My client chose to simply not demand a deed, to not do anything more than send out the redemption notices and so on. They did not end up with the property, but they also did not end up being responsible for any of the toxic waste or other environmental contamination that existed there. A couple more examples here. We had a Florissant residence, a big, beautiful McMansion in a McBride development. Lady lived there. She was an owner-occupant. She was behind on her taxes for many, many years. She ignored the redemption notices, whether they were posted on her mailbox, posted on her door, sent to her by registered mail, sent to her by first-class mail. And then, when my client received a collector's deed to the Florissant residence, my client asked me to file a quiet title lawsuit. The same lady who is dodging the mail and so on also dodges the process server and the sheriff's deputy and so on, and could not be personally served. No one was going to hang out outside of her garage for 3, 4, 5 days or weeks until she decided to back out and then serve her with papers or notice of a pending quiet title lawsuit. Therefore, the court allowed for service by publication. Service by publication happened and the clerk's office mailed a copy of the published notice, published in a legal newspaper, to the lady at the residence. Still nothing. After tax sale purchaser, my client, obtains a quiet title judgment, the taxpayer finally wakes up, lawyers up, and asks the judge to set aside that default judgment for certain good reasons. And the case dragged on for months. The tax sale purchaser, in this particular unique circumstance, did end up prevailing. However, it took much, much longer. For another example, I have a big commercial building. Maybe it's on Page or Natural Bridge or some Dr. King or some other prominent industrial commercial boulevard in St. Louis County. The building sold for back taxes, 3 years taxes, first offering. My client pays that amount, pays more. That's in August. Now we get to December, and another year's taxes kick in. That amount is, let's say for purposes of argument, $9,000. It's a big commercial building after all. Tax sale purchaser pays the $9,000. Little while later, the taxpayer wanders into the collector's office and says, hey, how much to redeem my property? Collector says, those 3 years of taxes that were the sticker price and the opening bid amount plus 10%, write me a check, here's a receipt, your property has been redeemed. Redemption check comes to my client, the bidder at the auction. She calls and says, my check is $9,000 short plus interest. I did not get back the money that I paid for the subsequent year's taxes. Terrible, terrible problem, because now we have two people showing up in a courtroom arguing against one another, one of whom has a collector's deed and one of whom who has a certificate of redemption, a receipt saying their property has been redeemed from the tax sale, but the problem is that the county collector of revenue simply told that tax sale purchaser the wrong amount. Those are the kind of cases that need to settle. We also had a case recently with a property way out in West County, and the taxpayer was a trustee. Specifically, wife and husband had owned a property. Wife and husband chose to deed the property to a revocable living trust. The grantor, settlor, an initial trustee of which was wife. That trust document is absolutely private. It is not registered anywhere, etc., etc. Husband dies, wife dies. Tax sale occurs. Naturally, no one paid the taxes. And then the tax sale purchaser succeeds at bidding in Clayton or St. Louis County's sealed bid auction, obtains a collector's deed to the property. The quiet title phase comes around. Who are my defendants? Who do I serve and sue in these particular facts? Doing a little bit more digging, we never found out a copy of the trust document. That's a private document. And we learned that the beneficiaries of the trust, well, actually a successor trustee after the death of the grantor wife was a brother. He also died. And then who were the beneficiaries of the trust? Allegedly 2 or 3 dog-related rescue charities. I don't know which one. There's no copy of that trust document put anywhere, registered in any government office, submitted for probate anywhere, and therefore it becomes very difficult to do the quiet title. You should know that in general, there are at least a couple title companies in St. Louis that are friendly and nimble with tax sales. They're all not terrible the way that I said on this screen over here. What does all this cost? I usually have somebody ask at this point, and the answer is In the city of St. Louis, we can usually offer a flat fee, a package price that takes care of one size fits all most situations. In St. Louis County and other Missouri counties, these are almost always time and materials jobs. Usually the materials, that's the process server, that's the filing fee, that's the legal newspaper, that's the recorder of deeds, that's the certified copy, that's the sheriff's deputy, end up being about half of the cost. Phase one, however, is I bid in an auction, I got the lien, now I need to give notice of the right to redeem. That's going to be a situation where the cost of the title report, the cost of the stamps, postage, maybe the cost of additional efforts to post the property or otherwise notify the taxpayer or a lien holder or heir may be reimbursable should redemption occur. In phase two, the quiet title, the cost of those expenses goes up much greater because we're talking about all the categories that I described a moment ago. When do you need help if you choose to buy at one of these auctions in a Missouri county other than the city of St. Louis or Jackson County, Kansas City area? You need help right away if what you buy is a third offering tax sale. So if you go to this auction, submit a sealed bid, show up in St. Charles, show up in Potosi, and you win a third sale, you need help right away. If, however, you buy a first or second offering lien at a tax sale in most Missouri counties, you will need help in the spring, but you should pay the taxes in the winter, and you only need help in the spring if redemption has not occurred. The quiet title or eviction or ejectment phases of the process can happen later on or never or immediately, depending on your preference. For instance, one time I had a lady. She bought the vacant lot next door to her house. She bought it because she wanted to have more room for her grandkids, her tomato plants, her swing set, her pool installation, whatever it was. And she told me that the taxpayers and record title owners had been dead for many years. She told me that she had been mowing the property and maintaining it for many years. And she was the successful bidder and redemption did not occur. Then she called me and said, Dale, I need you to start on this quiet title lawsuit immediately. And I said, for the love of God, why? And I said that because there was no big hurry. It's not like we needed to put somebody out or anybody thought somebody was coming over there. We did eventually, within a short amount of time, proceed with that quiet title lawsuit to shore up her collector's deed and give her better marketable title. But we didn't need to do anything immediately under those circumstances. I'm Dale Sweet. I'm an attorney. I may be your attorney, but I'm not your attorney unless you're my client. What I've done here tonight is provided general information unrelated to any particular situation, much less your situation. The choice of a lawyer is an important decision, should not be based solely upon advertisements. If what we just did in the last hour and 15 minutes is even an advertisement, folks, I don't know. It was great to be with you tonight. My telephone number is 636-TAX-SALE. My email address is on the screen there, dale@MissouriTaxSales.com. I have a free email list, delighted to put you on there. I send out geocoded maps like I showed you an example of earlier. I send Excel spreadsheets so that you don't have to try to pore over government websites and legal newspapers, so you can sort the information however you like by zip code or municipality, etc., etc. It was absolutely phenomenal to be with you here tonight. I appreciate the few questions that we received, and now I wish you good night and good luck.